seated, thank you.
Are you okay beginning without your counterparts, Mr. Mark?
Yes, ma'am.
And here's your copy back. Thank you. I've read mine out of my office of the transcript. Thank you. Go ahead.
Good morning.
Good morning.
During the course of the conversation that you had with Mr. Michaels, well, let me start over. What I'm going to try to do, I want to go through certain topics with you. I'm going to jump around a little bit, but what I plan to do is tell you when I change from topic to topic so that you and I can talk about the same thing. Fair enough?
That's fine.
All right, so when I say you had a conversation with, that's we're changing topics and we're going. All right, you had a conversation with Mr. Michaels during direct examination where you indicated when you were going through Mr. Reeves' statement that you saw, at least in your mind, in the video, Mr. Olson engaged in certain conduct by turning in the seat or whatever he did. There was a lighted object. Remember that conversation?
That's correct.
All right. And you said that that is where Mr. Reeves says he was hit. Remember that?
That's correct.
All right. Then we had another conversation with Mr. Michaels dealing with the reaching in towards Mr. Reeves. Remember that conversation?
That's correct.
All right. Now, Mr. Reeves told you that he believed that he was hit with a fist.
He said a fist, could have been a fist. He didn't necessarily know if it was his fist or not, but it could have been.
In fact, from his statement, you know that he said that he was hit with such force that he was dazed. Remember that in the statement?
Yes, I do.
You're going to have to speak up just a little bit.
I'm close to, I can get this closer.
There you go. I appreciate that. Thank you. He also indicated that when he was hit, that his glasses became askewed on his face. I know he didn't use the word askewed, but they weren't knocked off, but they've become not adjusted correctly on his face. Remember that?
Yes, I do.
All right. He also indicated to Mr. Michaels that you took it upon yourself to discount the patron's statements because, in your opinion, you believe they were contaminated and not worthy of your consideration, right?
Not quite in those words, no.
All right. You did not factor those into your opinion, correct?
That's correct.
All right. What you relied on the statement of Mr. Reeves along with your perceptions of what occurred in the video, correct?
That's correct.
All right. Now, in making a determination as to what information you're going to use in order to form a basis of your opinion, you would want to make sure that that information is accurate, true, and correct.
That's correct.
You know, as a law enforcement officer, that an individual who is a suspect in a crime, who has been taken into custody, has the motive to not be quite truthful with the person conducting the interview, right? You've had that occasion.
It depends on the individual. Can't say.
Yeah. But it does happen, right?
I'm sure it does.
And you have to take in consideration whether you know or did not happen that an individual who is trying to explain a situation so that he can go home to his wife and children has a motive to either embellish or misdirect the officer in the attempt for that goal, I want to go home. You have to take that into consideration, don't you?
Well, I try to take into consideration the facts of the case, what I read, and try to understand it from a reasonable standpoint.
That wasn't my question. I appreciate your answer, My question to you was, in determining the credibility of the information that you received, you have to take in consideration that a person who is arrested has a motive to lie. Right?
I take a lot of things in consideration, and being not truthful might be one of those things. Is he truthful or not? And I don't know.
You don't know that?
I don't know until you go through the facts of the case.
Now, Dr. Hayden, you come in here and you told us that you're an experienced federal agent. You've been to numerous places. Are you telling me that it's your life experience that individuals who have been arrested don't have a motive to lie?
Not always. I don't know what branch you're looking at, but in my experience, some people that come in are very honest with you. Some people are not telling you the truth. Some people are way out in left field someplace.
All right. Now, having said that, my question to you, in determining the credibility of Mr. Reeves, you had to take into consideration whether or not he was being truthful to you. Based on your life experience, some people lie and some people don't when they're in custody, right?
Yes.
All right. And you indicated that you determined the credibility of Mr. Reeves by watching the video and going to cop theater and making a determination of certain facts that he said. And we're going to go into the facts, but very generally, that's what you did, right?
Yes.
Objection. That wasn't what the testimony was, Your Honor. That's an improper characterization of the testimony. The testimony was.
Excuse me. He just said yes, it was. Now he's trying to explain the answer of his witness.
Hold on, one at a time.
But I didn't yell over the prosecutor, and I don't expect him to yell over me.
Go ahead.
But Judge, what we have with both Mr. Escobar and Mr. Michaels is constantly interrupting so that they're teaching their witness what to say. That's been going on for days and days and days.
Hold it. Stop.
Teaching witnesses.
Do you think this poor young lady is a magician? One at a time, gentlemen. You know the rules.
Thank you, Judge.
Mr. Michaels, you started.
I appreciate that. My objection is that it's an improper characterization of prior testimony. I think the court has notes, and my recollection is the prior testimony was not that Dr. Hayden relied solely on the evidence that he saw. He relied on his personal experience. There are a lot of things he relied on to make his determination as to whether Mr. Reeves was telling the truth, not only what he saw in the video. So I think it's an improper characterization of what his testimony was. So if the question is to tell the prosecutor what it is that he considered, if he has any specific questions regarding specific areas of what Dr. Hayden used in his examination of the interview he did with Mr. Reeves, then I think that's fair. But characterizing it as strictly going by the video, I don't think that's not accurate.
Response?
Judge, my question was, you used the content of the video and your experience at Cobb Theater in order to corroborate Mr. Reeves. That's what I said. And he said yes, because that is true. Because you remember the questions, I sat in the seat, I couldn't get up, I couldn't move to left or right. And he said yes.
I'll overrule. You can redirect if you wish, and I am taking notes. So.
I know you are, Judge.
Go ahead, Mr. Martin.
Let me have this one. My question to you, Dr. Hayden, was in determining the credibility of Mr. Reeves, you relied on your interpretation of the content of the video and your experience at Cobb Theater when you went in there with Mr. Escobar, correct?
And I said I relied on a lot of things, not only being in the theater, but talking to Mr. Reeves, to interacting, looking at the video, a lot of things.
Those were two of the things, was it not?
It was two of the things, yes.
Okay, thank you. Determining the credibility of Mr. Reeves is very important to you as an individual who's going to come in and opine whether or not his conduct was reasonable under particular circumstances, right?
It's not just what he says, but a lot of things, whether it's reasonable or not.
I appreciate that, Dr. Hayden. My question to you was, in determining the credibility of Mr. Reeves is very important to you.
It's one of the factors.
The credibility of Mr. Reeves is very important to you if you're going to rely on his statements to you as one of the bases of formulating your opinion.
If it was the only thing, it'd be very heavy. But if it's not the only thing, then it's not. It's just a consideration.
I'm going to ask that question one more time.
Judge,
And please allow me to
already
do
answered the
that.
question.
No, no,
Ask and answer.
no.
Overruled.
Determining the credibility of Mr. Reeves is very important to you as one of the factors that you're going to use in formulating your opinion, is it not?
It's a factor, yes.
In your discussions with Mr. Michaels, you indicated that you wanted to sit down and speak with Mr. Reeves and ask him the why questions, how he was feeling, his perceptions. You remember that line of
That's
questioning?
correct, I do.
You remember the line of questionings when he was going through the statement of Mr. Reeves to law enforcement and what he said to you. He kept asking you, is that consistent with what he told you? You remember responding that way?
I do remember that, yes.
The conversation continued between you and Mr. Michaels regarding you can't really look into someone's head. And as Mr. Michaels indicated, you can't look at the scary part in the head and determine if it was activated. You remember that
I
conversation?
remember that conversation, yes.
Right. And that's true. When someone's telling you what they felt or what they perceived, first of all, you have to take what they say at face value and then try to corroborate, right?
You do, yes.
But feelings and perceptions, very difficult to corroborate, are they not? If not impossible.
I wouldn't say not impossible. You have to look at all the different factors, and then you'd be able to give an opinion on that, yes.
As to whether or not someone's afraid.
Yes,
Of what
absolutely.
their intent was.
Yes.
What their motive was. You can do that by talking to someone.
I'm not saying I can do that. I'm saying that is a factor that you have to look at. And trying to understand fear. If you look at fear, you try to understand why fear occurs and what happens to the individual.
I understand that, but we're talking about Mr. Reeves. And your very final opinion, you said that he honestly believed that it was necessary to shoot Mr. Olson. I know that's not your exact words, but that's the bottom line of your testimony, right?
That's correct.
Right. And that's what I'm trying to go into, is the underlying factors that led you to that conclusion. And what I'm asking you is, or discussing with you is, when we talk about someone relating their perceptions, as far as feelings and state of mind and emotion, you first have to take their words at face value and then see if there's any facts to back it up, right?
I don't take the words at face value, but I do try to back it up with other things that might be there.
And you don't take it at face value, especially with someone who's been arrested and maybe have the motive to embellish or lie about what took place in order to achieve a self-serving goal, right?
I don't know what their emotion is at that time. What I'm trying to do is I'm trying to understand. So I try to look at everything in a reasonable fashion and trying to understand with being objective about it.
Did
Not
you
including
understand my question? I don't mean
I
to
guess
be
I didn't, because I think I'm answering your question.
In determining the credibility of information provided by an individual that cannot be corroborated, one of the things that you can look at is verifying whether or not those things that can be corroborated were in fact true. That's one way to determine, are you going to believe what we can't corroborate if he was truthful about other things, right?
That's part of it, yes.
All right. As a very simple example, a suspect says, I was hit, and therefore I had to engage in conduct A, which you determine that that person wasn't hit. You take that in consideration as to whether or not his conduct A was in fact reasonable since he wasn't hit. That's the analysis that you go through, right?
That's part of the analysis you go through, trying to look at all the facts and trying to balance it out.
But that is one of them.
That's basically one, yes.
And in this particular case, if it was shown that a cell phone was not thrown at Mr. Reeves, and he was not hit with a cell phone, he was not hit with a fist, your opinion in this case would be different, wouldn't it?
If it could be factually documented that that did not happen, then my opinion might change. I'd have to look at the rest of the situation.
How it might change?
It depends on everything else that occurred.
There'd be no escalating of violence, would there?
I don't know if there would be or not. Just the punch that you're saying is not the only one factor. There's several different factors you have to look at.
But it sure would call it into question, your opinion, wouldn't it?
What you're looking at is perception. What does he actually believe? And so would it affect my opinion?
Dr. Hayden, did you understand my question?
Obviously, Mr. Martin, I didn't understand your question because
So
I
my
think I'm
question
answering your
was-
question.
One at a time, please.
My question to you is that in the event that it was shown that Mr. Reeves was not hit with a fist or the cell phone was not thrown, then that would definitely call into question your opinion. Yes or no? Then you can explain it, but first, yes or no?
And there's not everything that's an easy yes or no.
You can
When
explain it.
when
Yes
I look
or
at-
no?
when-
Judge, I'm asking the court to instruct the witness to answer the question. He can explain it all he wants, but I want a simple, one-word answer to that question. And I'm entitled to that. He can explain it later.
Correct, with the ability to explain, you can answer.
Yes or no?
Let's answer the question again, please.
If it was shown that the cell phone was not thrown at Mr. Reeves and he was hit in the head with it to the extent that he was dazed, or that he was hit with a fist in his face to the extent that he was dazed, if those things were shown not to happen, it would seriously call into question your opinion in this case. Yes or no?
When you put one word there, I'd have to say no.
And why is it no when those things no longer exist?
Because you're saying would seriously consider it's a factor. Because you're looking at the perception of what he believes at that time. Does he believe he got actually hit in the head or not? So it's perception at that time. It might not be exactly what happened, but it is a perception.
So you're telling me that perception, getting hit in the head with a fist, if it didn't occur, you could perceive that pain? Is that what you're telling this court?
I'm not telling the court that at all.
Well, that's what you said, is it is perception as to whether or not he was hit or not. So you're telling me that you could perceive pain and that is a viable mental state? That I was hit in the head justifying shooting somebody?
I did not say that.
You either were hit or you weren't. There's no perception about it, correct?
Yeah, there is a perception. Perception a lot of times depends what's going on in your mind, what you believe. If you believe you're being attacked, there's people that believe they've been hit. I don't know at that time. I'd have to look at everything else, not just one factor.
Defense exhibit, is this yours, Madam Clerk, up here? On the blue one? Defense exhibit 27. Picture's been passed around, many people have looked at it. One of the things you would consider is whether or not there's any injuries about the face of Mr. Reeves, consistent with a punch to the face or being hit with a cell phone. That's one thing you would consider, right?
If I saw damage, yes, it would be one thing that would be another consideration.
And you don't see any damage there, do you?
I'm not a doctor, but looking at this, I don't see any damage, no.
You went through several of the statements of Mr. Reeves and said, yes, I looked at the video and I saw that, or I didn't see that. You remember that line of questioning? Where you went through with Mr. Michaels?
Yes.
All right. And you remember the discussion with Mr. Michaels where it was asked whether or not when Mr. Reeves was stretched fully out, he had his left hand extended, and there was discussion about that's what somebody would do if they're trying to ward off attacker. Remember that?
Yes.
And you said you looked at the video?
That's correct.
And you saw that?
I did not see that.
Do you recall Mr. Reeves' statement to law enforcement? He further explained to law enforcement that when he had his hand out, he was either touching the shoulder or the clothes or the chest of Mr. Olson. You remember that in the statement?
That's correct.
You didn't see that in the video either, did you?
I did not.
You recall in his statement to Detective Proctor that he indicated he was fully stretched out and that he shot, and of course he probably described it in the audio statement. We don't have the benefit of that. But he shot, basically stretched out, and therefore it had to be an upward trajectory. Remember that?
Yes, I do.
He said he indicated he shot while he was fully stretched out. You remember that?
I remember that.
All right. You didn't see that in the video either, did you?
I did not.
You indicated there's a part in the video where you believe that some body part of Mr. Olson came over the seat, and you said you saw a light. You remember that?
That's correct.
And you indicated that that's where Mr. Reeves believes he was hit, right?
That's correct.
Some 11 seconds before the shooting, I believe, was your testimony.
That's correct.
And in looking in that video, at that particular time, after you see what you said was Mr. Olson with some type of body part extended over the seat, immediately after that, you see Mr. Reeves lean forward towards Mr. Olson, correct?
That's correct.
You did not see Mr. Reeves in that video grab his face like he had just been hit with a fast pitch from a baseball, right?
I didn't see it in that video, no.
In fact, when you said you see that light, and that's where Mr. Reeves said he was hit, after he leaned forward, he then leaned back and settled back into his seat, did he not?
He moved back into his seat, yes.
He didn't get up and go attempt to get any medical attention, right? He didn't stand up at that point?
Not at that point. I don't believe he wanted to stand up because he thought it would put him in more danger.
And as you mentioned, after looking at that photograph, you didn't see any injuries on his face, right?
I didn't see any injuries, no.
And those are the type of things that the trier of fact can look at in determining the credibility of Mr. Reeves as far as his statement, correct?
That's part of the factors, yes.
And the reason it's important because Mr. Reeves is describing conduct that we cannot see in the video, right?
That's correct.
So in order to believe Mr. Reeves' statement about what we cannot see, it would be very helpful for us to believe what we can see. Would you not agree?
That's just a factor. You're putting it all together.
Now, we've gone through several items where Mr. Reeves has made a statement to law enforcement about what occurred that we do not see in the video. Remember that? We just had that conversation, right?
That's correct.
Some of those statements that we cannot see in the video, and I'm going to point to two of them, all right? Would be a factor in considering whether or not his actions were reasonable. And I'm going to go through the first one and the second one. First one is when he said that he had his hand out and he was touching Mr. Olson's chest or shoulder and he was virtually on top of me and he shot him. Right? That's what he told law enforcement, right?
Yes.
Well, that's not what happened in the video, was it?
That's not what happened, no.
But that particular statement is very weighty as to the close proximity of Mr. Olson and what Mr. Olson was doing and how imminent the threat was, correct?
So many other things that take consideration, not just what you see.
I'm asking you a specific question, Dr. Hayden. That particular statement to law enforcement about Mr. Reeves being so close that he could reach out his hand and either touch his shoulder or his chest, and he was stretched out and he had to shoot Mr. Olson in that location, that is some very weighty evidence about whether or not his actions were reasonable, because the threat is very imminent. If he's in his lap and his hand on his shoulder, and he's got to shoot while he's straightened out, right?
No, it isn't.
No, it's not?
That's correct.
If you saw that in the video, would we even be in the courtroom here today?
I don't know what you would do if you brought it into the courtroom or not. But there's so many other factors that you don't want to include in this that are essential that you include.
Well, right now, I get to ask you questions, and you get to answer them, okay?
Sure.
And if someone else wants to talk to you about them, I'm sure they will. But please answer my questions.
Judge, could you please instruct the prosecutor not to admonish the witness? You can ask a question, but it's improper for him to lecture the witness on answering the question or not answering the question.
Not when Mr. Hayden has been as non-responsive as he's been for the last 20 minutes to my questions.
All right,
That's
let's
the court's
just
job,
move on.
Brian.
Let's just move on. I'll do the directing now. Thank you.
In fact, Mr. Reeves, in that segment about his hand being forward, wanted to so convince Detective Proctor that that was true that he explained as a police officer, we never put our hand in front of the muzzle. And I thought I could have shot my hand. You remember that?
I do remember that.
Another attempt by Mr. Reeves to get Detective Proctor to believe how imminent that threat was, but that's not what we see on the video, is it?
It's not what you see in the video, no.
May I have a moment, Judge?
Yeah.
for the time, Judge. I don't have any further questions.
Thank you, Mr. Martin. Redirect?
Give me just a moment, Mr. Michaels.
I was just about to tell the judge I was going to give you a moment to gather your stuff. Because I definitely don't want to get close to him after that.
Yeah.
No, you don't want to get close to me.
Can we disinfect the
It's not the only thing Mr. Escobar and I haven't agreed on. Yes, y'all disinfect this. I apologize.
Judge, criminal defense lawyers are always in jail, so I've gotten every bug known to man, so.
I'm sure that's true. I know
All right.
that's the way
Sorry,
it
my
is.
fault. Thank you, Mr. Michael.
Now, I know the prosecutor talked to you a little bit about what you didn't see. You definitely saw Mr. Olson coming over the aisle and a lighted object appeared to be moving in some fashion, right?
Yes,
Your
I
Honor,
did.
I object. That wasn't his testimony during direct. He just saw a lighted object. Otherwise, I would have gone into it a lot more if he said anything different.
Rephrase.
Okay. One of the things that you saw definitely on that video is Mr. Olson and what appears to be his head, arm, and body, right?
That's correct.
Reaching over his road towards Mr. Reeves.
That's correct.
And there's some appearance of something lighted or a light area in the video coincidentally at that same time.
That's correct.
You saw crime scene photos and you noticed a phone, 100% you saw it between Mr. Reeves' feet.
I did.
You are aware of DNA evidence in this case. You got a report to review.
Yes.
And in terms of the outside case of the phone, could the FDLE, could they exclude Mr. Reeves as a possible contributor to DNA on that phone?
They
Your Honor,
could.
I object. No, 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 no. No.
Yes, it has.
We need to approach. Madam Clerk, can we have the DNA stipulation, please?
Wait, we have a court reporter. Mr. Martin? Oh, wait.
Step up real quick. Okay.
So you're able to look at the DNA report provided to you by us, those provided to us by the state.
That's correct.
And in terms of the case, what is the long and the short of it? What conclusion did you get in terms of the outer part of the case as it relates to Mr. Reeves?
What I understood,
Judge, I put an objection to that question. How he interpreted the report is not relevant. He wants to read the report word for word, but his interpretation, he is not a DNA expert. He hasn't been qualified for that. He doesn't know how to make those interpretations.
Can we just read the stipulation? Simple as that. I don't have a problem with that.
You either got to lay a foundation or you can read the stipulation.
Which stipulation?
I read the stipulation. So.
Well, the court read the stipulation, and in terms of the case, due to the limited nature of the DNA results obtained from the iPhone's black case screen, the data is insufficient for inclusion purposes, but may be suitable for inclusion. I'm sorry, I read it out of order. Number one, the DNA obtained from the iPhone black case, AP13 black case, demonstrated the presence of a mixture of at least 3 individuals. Due to the complexity of the mixture obtained from the iPhone black case, exhibit AP13 case, this data was not interpretable. Paragraph 2, due to the limited nature of the DNA results obtained from the iPhone's black case screen, exhibit AP13 screen, this data is insufficient for inclusion purposes, but may be suitable for exclusion. Due to the limited nature of the results obtained, Chad Olson can be neither included nor excluded as a contributor to the iPhone's black case screen, exhibit AP13 screen. Paragraph 4, Curtis Reeves, exhibit AP13 screen, is excluded as a source of the limited DNA source obtained from the iPhone's black case screen. Now, there was the phone in the video. What we can see is you see a movement about 11, 12 seconds later, correct?
That's correct.
By Mr. Olson towards Mr. Reeves.
That's correct.
You see Mr. Olson's hand come out?
And the second occasion or the first one?
The second?
Second occasion, yes, I do.
We're already past the first one. You see the hand go back?
Yes, I do.
And the hand come back out?
Yes, I do.
In between, there's popcorn grabbed.
That's correct.
Did Mr. Reeves at any time tell you that Mr. Olson told him or indicated in any fashion that, hey, Mr. Reeves, I'm going to take your popcorn?
No.
And so in terms of perception at that point, what is an individual seated in the seat in that sort of theater, in that sort of setting, what sort of perception is reasonable at that point? What are you looking at?
Your Honor, I'm going to object at that point as far as his expertise and as far as determining that particular question. You know, what is reasonable and not reasonable sitting in that location. He's already rendered his opinion. He believes Mr. Reeves was honest in his belief that he had to shoot Mr. Olson. Now, whether or not I apologize, Dr. Hayden, you know, now can come in, we do this reconstruction that we heard about that is kind of interesting. He can't answer that question.
Judge, I'm going to object to those gratuitous comments, number one. I appreciate that the prosecutor finds it interesting. I only wish that the police found it interesting enough to try it themselves before they even arrested Mr. Reeves, but that's another matter. Nonetheless, Your Honor, I'm just asking what the perspective was in terms of what is reasonable for an individual in that particular environment to perceive. In other words, is that person perceiving that the individual who's been cussing and come over the aisle before is now going to grab the popcorn, or is it reasonable to perceive it as a threat? Okay. Is it reasonable to perceive that motion that we see 12 seconds later after the first throwing motion as a threat?
Yes, absolutely.
And as the hand comes back and goes forward again, would it be reasonable to perceive that particular second motion as a second threat?
Absolutely.
Or a continuing threat?
Yes.
Yeah, I'm sorry, Judge. I know it's all right, but I didn't. Thank you. Now, to the witness, please. All right, this is exhibit 27. I know the prosecutor showed it to you. You looked at it. I know you're not a doctor, but do you agree or disagree with me when you look at what would be Mr. Reeves' left eyelid?
Judge, I'm going to object. I mean, I don't care about agree or disagree. When you're pointing at something, he's already looked at the picture and said, I saw nothing. Now, if that's not totally suggesting the answer, I don't know what is. When you point at a red mark and say, would you agree or disagree, when he already had an opportunity, fair opportunity, to look at the picture, that's absolutely leading.
Judge, I'm not leading. I'm indicating the area that I want him to draw his attention to.
All right, I've been sitting here.
And Judge, I don't want to interject, but he said damage in the question to Mr. Hayden. He did not say anything. He said damage. And the use of words is very important.
Here it is. I heard the prior testimony. I get it. I figured this was coming. It is absolutely leading to some extent, but then again, I guess you're entitled to direct him to certain areas of the photograph. So.
Let's look at this photograph, exhibit 27, okay? Now look closely, take your time, please. I know you're not a doctor. Direct first your attention, if you would, to the right eyelid and then work yourself across the face to what would be Mr. Reeves' left eyelid and your right. Okay?
Yes.
All right. Can you see this all right?
Yes, I can.
All right. And do you see any thing that appears to be any redness on either eyelid?
He says, yes, I do. I see the redness on his left eye.
Okay. And would that be consistent with somebody getting hit in the eye?
Judge, that's called for speculation.
Well, Judge, the prosecutor asked the question.
I'll allow it.
Is that consistent?
Be consistent with him having his eye affected. So,
And be consistent with having his glasses knocked to the side?
yes, it would be.
Now, as a special agent and then training police officers, are there certain techniques, interrogation techniques, on a suspect or a subject that is willing to talk, that you use to try to get information out of them?
Yes.
And is that, are those techniques used to try to ferret out the truth the best you can?
It's called cognitive interviewing techniques, and it's to get to the facts of what actually happened, what he believes happened, and not to trip anybody up, but to try to get as many facts as you can.
Okay. And in terms of, as a police officer, are you aware that individuals that are arrested have the right absolutely not to speak to you?
Absolutely.
Can I have a moment, Judge?
Mm-hmm.
That's all I have, thank you.
Can this witness be released?
We're going to keep him under subpoena, but most probably will not have to recall.
That, I
You can
don't
go
know
back
when
and
on
retrieve
earth
it
we
from
might
after.
get the time to do that, but that magical time that he'll be on standby. Dr. Hayden, you are free to go today. You will still be under subpoena, but hopefully we won't be calling you back. If someone does have to call you back, I'm certain they will give you plenty of advance notice.
Okay.
Thank you, sir.
Thank you very much, Judge.
All right, 11:20.
Just, if we could take an early lunch, I think the last thing I want to do is to break up my presentation of Mr. Reeves. So we're going to have to take a lunch sooner or later, so it's
I'll give you
11:30.
that option. It is a pretty early lunch, but if you, because obviously, I'm guessing we're not going to finish Mr. Reeves' testimony before 12 o'clock.
I think that's, especially with me doing the questioning, I would think that.
All right. And if you're requesting not to break up his testimony, then I'll oblige and we'll go ahead and take an early lunch.
Thank you, Your Honor.
What do we need, an hour and 15 minutes, say 12:30? That'd be enough time?
Yes.
Yeah.
All right, that's a little over an hour. We'll reconvene at 12:30, be in